Let's get back to some of the lifestyle conditions and things that are asked of us about, how they affect Social Security disability application. I'll use one specific that's come in here, and we had a person write in and said, I drank 6 cans of Pabst Blue Ribbon and drove my car, and I thought it was great, but the officer that pulled me over didn't, and I'm trying to file for Social Security disability. Is this going to affect anything?
Yeah, that's a good question, and it comes up not infrequently, and that is that if alcohol or drug abuse is what they call a material contributing factor to the disability, then the person is not eligible for benefits. So when I've got somebody who's got an alcohol issue in their background, and again, it's in those medical records, and medical records, by the way, you got to be very careful and when you talk to your doctor, because if a doctor senses that you're drug seeking, going from doctor to doctor to get narcotic prescription, or there's a discussion of alcoholism in there, that can be a real problem, because Social Security sees that, they'll cut you off, or they'll deny you on that basis. If alcohol is involved, then there's got to be something else, at least in my take, there's got to be something else that would make the person disabled, or the alcohol use has got to be so long and damaging that the person has some sort of organ damage. In other words, if you drink consistently for 15, 20 years, then your liver is probably going to have an elevated liver enzyme. Your disability might have stemmed from the damage to your liver, even if you stop drinking. But yeah, if someone has been drinking, that's definitely not a good thing. And I will tell you from my experience that anytime the judge sees that, they automatically get very, very concerned, and those cases are very unlikely to be approved. Okay. A second area that comes up, in fact, came up in my office yesterday, I get letters from prisoners quite frequently.
Okay.
Because they're disabled. If you're in prison or in a state mental hospital, you're not eligible for benefits until you get out. I will tell you right now that the judges are not real fond of approving people who have long prison records, because it just affects their credibility. So those are a couple of areas you got to really watch out for.
So if you're a felon, you have to be very conscious about that, as well as alcohol or drug-related addictions or convictions.
Right. It used to be, years ago, alcoholism or drug abuse could be the basis for disability, because, again, it's perceived by, I think, the American Medical Association as a disease. But I think there was a couple of these reports on various TV programs where people who were drug addicts were using Social Security tax money, their money from taxpayers, to support their habits. They took that out. That's probably not a bad thing. I think those people are probably just making things worse for themselves. But, yeah, that's something that when I look at a case, I'm very, very concerned about if I see any kind of alcohol or drug use.
Yeah.
And I always tell people you need to get help and get sober, because judges will many times not approve the person until they feel that they are sober. The other thing is that people who are alcoholics or drug users sometimes tend to be a little optimistic about when they stopped or have they stopped, and judges are very aware of that as well.
Okay. In moderation is okay, but just don't abuse it.
In my mind, I just think that anytime really alcohol and drug use should not even be a part of a disability record. So,
okay.
Of course, you take clients as you find them, but if somebody has got that in the record where they've had some issues with abuse of substance, then that is a factor that might lead me not to take a case, because those cases are more difficult. Some judges are just, knee-jerk, going to react to that, and they're just not going to approve those people.
Okay.
I'm not saying that every one of them. I'm just saying that's just another factor to consider. And what I would say is if it's there, if a claimant has had some drug issues, they need to make sure that it's very clear in the record that they are past that is over and done with. They're not actively engaging in those activities. That can maybe cut that off in the past. And, of course, the biggest thing is don't lie about it. If somebody has had problems, they've had relapses, acknowledge it, deal with it, but don't lie about it, because it'll show up in the record.
Okay. Here's the sensitive subject, and you talked about it briefly in the beginning. The process to receive benefits is long. If you need a listing, then 6 to 8 months, and that's the minority of the cases. So the question that we hear is, how do you survive? What do people do? Do you have any advice for them or tips? How do you address that?
That's tough. It's a real tough one. A lot of people end up moving with family or friends, and they struggle. And I think that part of it is to have a realistic expectation of what's going to happen, so that you don't expect things to happen quickly, to realize this is a marathon, not a sprint, so you've got to keep going to the doctor. You have to make sure that your loved ones understand that this is not going to be something that's going to be very, very quick and rapid. Is a real problem. I think that's one of the things that Social Security is trying to grapple with, to make the process a little bit shorter, but we'll just see how that happens. I have had some success when people are facing foreclosure or facing imminent being on the street, where they can turn to their elected representatives, and sometimes those cases, we call them dire need cases, can be moved to the front. That is much less effective than it was a few years ago.
Okay.
But every once in a while, if somebody, especially if they have a terminal condition and they are dying, those cases will sometimes be moved to the front if you get an elected representative, senator, or congressman involved.
What about working through this? I mean, we talked about that before. I think you mentioned it wasn't if you're working and that's noted in your application, then they're saying, well, why do you need Social Security disability? Is that accurate?
Yeah, and I think that's a very good point. People say to me all the time, well, can I work part-time? And here's how I've sort of come down on this, is that on one hand, a failed work attempt is helpful to your case because it, number one, shows good faith, and number two, it shows that you are trying to do something but you can't. So clearly, if somebody is motivated to work but can't do it, that's positive evidence. If you've got 5 or 6 work attempts where you last 2 or 3 weeks at a particular place and you get fired because of absenteeism or because of inability to get through a work day, then that can be good evidence. Where I run into trouble is when somebody has got work attempts where they've worked 3 or 4 months. And really, once you get beyond 3 months, it stops being a work attempt and it looks more like a job. I think that muddies the water. So I would never tell somebody not to work, but I would just tell them if they do work and they get beyond 3 or 4 months, that is going to make it more difficult to prove they're disabled. Because no matter what job you have, there's probably something a little bit easier out there. And a judge would conclude, well, if they could last 6 or 8 months at a job in a warehouse, maybe they could do something full-time as a textile inspector or as a hand packer. So in my view, work efforts, if it gets beyond a failed work attempt, can be detrimental to a case.
Okay. Good to know.
Basically, Social Security sees things in black and white. Shouldn't be this way, but it is. They see things in black and white. If you are working, by definition, not disabled.
So do you have direct advice for your clients?
Direct advice in the sense that I tell them, they say to me, can I try to work? I said, sure, go try to work, but be aware that if you last more than, say, 2 or 3 months, may put you in a closed period situation where we're asking for disability from a period of time that comes to an end, or it may change our onset date. We may find that our onset date has been moved forward so that you don't get as much back benefits.
Yeah.
But, yeah, if you got to eat, you got to eat. But, again, Social Security's attitude is if you got to eat and you can work, then you're not disabled.
Yeah. It's really a catch-22. I mean, I don't know if I'm speaking out of turn here, but the cleaner way is to not work because then there's no area for confusion. I'm not working and I can't work. Here's my deal.
Right. That's exactly right.
Yeah. Back to the amount of money that people get paid real quickly. Does everybody get paid the same amount of money? Tell me how that works again.
Well, they get paid based on something called the PIA, which is a calculation that Social Security does, looking at their household, looking at what they paid into the system, and it's a function. It's a mathematical algorithm. I couldn't begin to explain to you exactly how it works, but it is a number that is a function of what they paid into the system. So somebody who's been a high earner, who's earned $100,000 a year, they're going to be getting a lot more money than somebody who's been earning $15,000 or $20,000 a year.
All right. I noticed that in some of your work, back on the tips and tricks that you work to go through the system. Well, tell me if I'm speaking out of turn here, Jonathan. But you advise people to claim a state of depression to work through their case. That sounds kind of wild to me, but I'm anxious to hear about it.
Well, first of all, you have to realize why. The reason why is that Social Security, if you allege depression, they will schedule a consultative evaluation with a psychologist.
Okay.
And it doesn't cost anything. And basically, my experience has been that most of the time, these psychological consultative evaluations, they will find something that limits you in some fashion. And really, if you think about it, it kind of makes sense. If you have been working your whole life and you've been a productive, self-sufficient individual, and now you can't work, there's probably going to be an element of depression, even if you don't realize it. And a lot of times, these psychological evaluations will uncover that. If you have any kind of learning issues that maybe went undiagnosed, they may uncover that because they do these various tests. So I find that in most cases, there's going to be an element of depression. At the very least, the psychologist will usually find something that could help your case. So I usually advise everybody, just as a matter of course, to allege depression because it's probably there, number one. Number two is because it's probably going to generate something that will help your case.
Okay. Well, I look at it this way. As a guy, speaking to other guys out there, if I was unable to work and my livelihood was taken away from me, and I am providing, which a lot of guys do, whether it's for yourself or for your family, I can see where somebody would have a altered mental state which may cause depression. That's just my take. I'm not a doctor. I'm just a researcher, but I see that. Okay.
Yeah. I mean, it makes perfect sense. If you've led a certain lifestyle, if you've had a certain vision of yourself and a sense of yourself, and all of a sudden that's completely changed, of course, you're going to be depressed about it. And that's a very reasonable thing, and I think that a lot of, especially men, don't necessarily recognize it. A lot of times the spouses do. But really for anybody, I think it's probably not a bad idea to at least have that evaluated. And again, 9 times out of 10 it will result in something that is beneficial to me.
Okay.
And you know what? If it comes back to there's nothing wrong, then you're no worse off.
Okay.
Now, by contrast, Social Security, if you allege any kind of physical problem, which in most cases are going to involve that, they'll send you out to a physical consultative evaluation as well. That's a different animal because those rarely help. Those are typically the IME type of doctors that you see in workers' compensation cases. They rarely find anything wrong with anybody. Judges give them very little weight. It's kind of a waste of time for everybody, but you've got to go through the process. So in most cases, most claimants will find themselves being sent out for a physical evaluation and a mental health evaluation. The physical one's not going to do them a whole lot of good. The mental health one might, but you might as well get it.
Okay. I'm going to look at this from a recap point and trying to piece together midway through here what we've gone through, which is somebody comes through, they've gotten started. Then we've talked about the guide and how the guide can benefit with the listing, functional work capacity. And we've spoken a little bit about how long it takes. So if they don't meet a listing, it could be 2.5, 3 years, right?
Could be. It depends on where they live. And again, some places are faster than others, but I think that a couple of years is probably a minimum, and 3 to 4 years is in the worst case.
Okay. So we've really zeroed in on the listing part. And I just, I hate to keep going over this, but these questions are asked so many times. I just want to make it clear to people what the key steps are. Are there any other things that you can think of that are important that we may have missed that should be discussed in coming through, getting started, getting that Form 7008, determining the medical problems, seeing if you match your listing in the functional capacity part?
Just a couple of points. One would be that there's a very short appeal deadline. When you get turned down, you have only 60 days, 60 days to file your appeal. So when you get your denial notice, you're denied, you want to do 2 things. Number one is you want to make sure that you file your appeal within 60 days of that denial notice. Because if you don't, they basically have to start over again. So that's important to do. And a lot of times they don't necessarily send you the form, the blank form. You have to either request it or get it online. So you want to give yourself plenty of time and not wait till the last minute to do it. But the appeal deadlines are very important. If you miss them, there are some cases you can argue you couldn't fill it out because of some medical condition or mental health condition, but it's best not to get involved. It's best to do them on time and get them done early. Again, that's part of what the guide will do, help you do is to get these forms filled out. Because 60 days seems like a lot of time, but if you're sick and uncomfortable, it can zip by. So be very aware of that. The second thing is when you get the denial notice, look at it. Say on the denial notice, what medical records were used to make that denial? And you'll find that a lot of times Social Security does not have all the medical records on hand when they make their decision. The reason for that is that when Social Security, the adjudicator, takes the file, and you provided them a list of all your doctors with names and addresses and so forth, if the doctor does not respond, if the address has changed, Social Security only waits a certain amount of time. And if they don't get those records back, then they just go with what they have. So I have several cases I've seen where people have gotten really strong medical records, never got to the file. The case was denied, and simply by providing those records, which I had in my office by that point, we got the case approved. So it's real important to see what they've got and to kind of keep track of what they have to make sure they've got all the medical records. Because, again, all they can do is request them. They don't do a lot of follow-up. They don't have the time or inclination to do so. But you as the claimant or you as the claimant's attorney, you can get on the phone, you can push the doctor to provide these records. So realize doctors' offices are under budget crunches like anybody else. Their reimbursements are down. And, making copies of medical records is kind of at the bottom of their list. And you got to sometimes push them. Social Security will pay, I think, $10 or $20 for this stuff. But for many doctors, that's not enough money to justify the effort. They just ignore them, ignore the letters. So it's important to look at those letters and see make sure you've got everything covered. And again, that's why you have your own file.
So this is really good advice for somebody that may have already started the application process.
You want to keep everything that they've given you, and you want to read it and look at it and see, because again, a lot of it's form, it's just boilerplate where they'll say, we denied you because this, that, and the other, but they'll say the following records were used to make this decision. They'll list the doctors and the dates of the records, and if you see something big is missing, then you know there's a gap to be filled, and you can fill it. That may speed the process up a little bit.
Okay, I'm going to move forward a little bit. You've done a great job of outlining that for us. Now can you bring us through this part of the program and address the confusion that people have as to when to get an attorney, if they need an attorney? I'm hearing here, if you can go and meet a listing, you don't need an attorney. All you need to do is get the guide, right?
Correct.
So when does an attorney come into play here? I mean, you see advertising everywhere, really, for this. So
right.
Tell us what we need to know.
Okay. I mean, first of all, realize how attorneys get paid, and that is that we attorneys are paid typically 25% of any past due benefits. In other words, if somebody applies, in January 1, but they allege an onset date of March 2 years ago, there may be a couple years of back benefits involved here. And so by the time we get to a hearing, maybe 2 or 3 years or 4 years. So attorneys get paid 25% of any past due benefits. So
that could be a lot of money.
Could be a lot of money, and basically it's up to $5,300. So,
oh, okay, it's capped.
Nowadays, right, it's capped. I mean, unless you can ask for additional fees if you've done more work, but most people do what they call the fee agreement. Typically when I win a case, I'll get checks for $5,225, which is there's a user fee involved, but basically that's what attorneys end up getting paid for these cases. So if you've got $20,000 or $30,000 of back benefits, which is not at all uncommon, the attorney's going to get paid 25% of that.
Wow.
Now, attorneys, again, I'm an attorney, but I'm telling you that the truth as I see it is that really there's not much we can do at the initial stage because the Social Security's got to do its thing there. Even at the reconsideration stage, which is a phase they're trying to move out, they're trying to get rid of it, still there in most places right now, not really much we can do. I usually get involved in cases when there is a hearing to be scheduled. So if somebody gets denied at the initial application or denied at reconsideration, then I'll get involved to request a hearing where I really earn my money.
Okay, we want to finish this topic, but can you tell us what is reconsideration? And maybe, let me give an example. Let's say somebody comes through and they fill out the paperwork and it goes through, whizzes by the adjudicator, and take it from there.
Here's the time frame. Somebody applies, it goes to the adjudicator, the state agency adjudicator, who will usually take about 6 to 8 months to collect medical records and evaluate it with the help of in-house physicians and other experts at the state agency office.
Okay.
So typically about 6 to 8 months after you file, you'll get a letter from Social Security saying, we have denied your claim. And of course, a lot of good cases are denied. You then have 60 days to file for what is called reconsideration. And again, reconsideration does not exist in every location. There's a number of different programs to eliminate it because it's such a waste of time. But it's still in a lot of places, so let's talk about it. Reconsideration is essentially where you fill out additional forms to update the record. It goes back to the same people that denied it the first time. And again, if let's say something was missing and you provided it, that's when the adjudicator can make a decision, approve a reconsideration. Statistically, very, very, very few cases are approved for reconsideration.
Can I ask a question here?
Yes.
If somebody at reconsideration sends in their original paperwork and they don't know about your secret and the guide and the listing strategy, and they refile their paperwork at the reconsideration level, is there a chance that they could meet a listing?
Sure, absolutely.
Okay.
And again, a reconsideration is not a refiling. It is simply you're asking for a reconsideration of the initial denial notice.
Okay.
But yeah, I mean, they're looking for the same thing. And again, the cases that are approved of reconsideration, I think, are ones where the medical record is kind of straggled in. The doctor was late and it finally got there, or something new has happened, and the adjudicator, has a justification for approving it. Now, again, I've had several cases where my client, a customer, bought my guide after the initial denial, before the reconsideration. And when they filled out the reconsideration forms, which is a whole different set of forms, they did it right and they got approved there. Statistically, reconsideration is a very low level of approval. I think your chances improve if you know what you're doing, of course, but it's relatively low level of approval system-wide.
Okay.
So again, the reconsideration process is going to take another 6 to 8 months, and now we're probably at 12 to 16 months into the process. You get a denial notice from reconsideration. It looks very similar to the one you got from the initial denial. then you have 60 days or 2 months to file for a hearing, to request a hearing. And at that point, the file physically is moved from the state agency office to the Office of Hearings and Appeals. And that is moving from the state of whatever, state of Georgia, state of Alabama, state of New York, to the Office of Hearings and Appeals in a federal government office building. And that's where the judge will actually look at the file. That process is where the 1.5 to 3 years goes into play. And I did a little research on this, and according to the government's own statistics, the amount of time, the typical case is taking about 3 years start to finish nationwide. Social Security employees work on that file for a grand total of 7 days.
Ooh.
7 work days in 3 years. The government's own statistics.
So I see 5 steps here. Somebody applies, and it goes through the adjudicator, and the adjudicator reviews it, collects medical records, and typically sends you back a yay or a nay. And if it's denied, then there's reconsideration. You have 60 days to file. Correct?
Correct.
Put any additional information in there, something that was left out, the reasons why you still take it. Okay. So that's sent in, and then there's 6 to 8 months may go by, and then if it's sent back, it's typically not approved at reconsideration. It would be denied, and then you'd have another 60 days to request a hearing, right?
That's correct.
Okay.
That's correct.
So when you request that hearing, what's the time between the hearing is requested and the hearing is
done?
Is done.
Again, that's where the big delay is.
That's
right
the
now.
biggest delay.
In Atlanta, it's 26 months.
Ooh.
The day you file that request or that appeal for a hearing to the time the hearing is actually scheduled. It's over 2 years. Now, in other places, it's going to be a little bit less time, but in several jurisdictions, in Georgia and Atlanta in particular, it's 24 to 26 months.
Okay.
If you think about it, the challenge there is, and there's a couple of things that are important to point out about this delay. If you remember at the initial and the adjudication section, you have adjudicators who are collecting medical records, at least requesting. Once you request a hearing, there's no more adjudicators involved. There's nobody updating the file. So it's you or your attorney has got the sole responsibility for updating that file. Make sure the medical records are updated. So that's why when you say, when do you get an attorney, I think that's where it starts to make sense to get an attorney, because keeping the file updated, knowing how to do all that, starts to become, some work.
Mm-hmm.
There's a timing aspect involved in it. And, plus another factor is that if for some reason you didn't have something included in your initial application or your reconsideration, your attorney can get that in early on. Because you don't want to get to a hearing, all of a sudden the judge finds out for the first time you've got a bad knee. That needs to be brought up much, much earlier. And a good attorney will look at the file and have a sense of what's the theory of our case, what do we need, and prepare the case for a hearing.
Mm-hmm. Yeah, so after you requested a hearing, you're on your own. There's no more adjudicators. So either way, if somebody really wants to venture out and do this whole process on their own and not get the guide, they just got to have impeccable records and know the language.
Plus, I'll tell you, going to a hearing, if you're not an attorney and you're going without an attorney to a hearing, it's not pleasant. I mean, the judges are overworked. In my opinion, this is just my opinion, but my sense is that most judges just get very frustrated with non-represented claimants because they have to take so much more time to explain the process to them.
Okay.
The files are rarely in the right order, and the person normally doesn't have any real clear idea of what they're trying to prove.
Are there other people out there other than an attorney that could represent, they have a better understanding of the process than the regular Joe layman?
Well, Social Security does allow non-attorney reps to go. And again, Social Security is unique in that you can actually represent somebody without being an attorney. Non-attorney reps, there's some good ones, there's some not so good ones. Again, they don't have, of course, not that every attorney is great either, but the nice thing about an attorney is you've got the screening process, the person's passed the bar exam. They probably have a certain level of capacity and capability. There's some non-attorney reps that do a good job, and there's some ones that don't do a very good job at all. So I personally think it's a little riskier to go with the non-attorney rep.
Mm-hmm.
But, there's some good ones out there. I've been asked the question, what good does my guide do if you have already passed the reconsideration phase? And again, this comes to preparing the case for a hearing. One of the things I think that's important to do is to really have the forms filled out correctly, the functional capacity forms, the listing forms. And one of the things I've got in there is those forms. So I think that even if you have to go to a hearing, it can be valuable to have your file, done correctly.
Mm.
I've got a lot of attorneys who buy my book because they want to fill these forms out correctly as well.
Is that right?
Absolutely.
Yeah, I'm looking at this from a business perspective, from a guy sitting on your side of the fence as a lawyer. Why would I want to represent somebody if they're just in the application process? Because the back benefits, that's what I would get paid on. I'm presuming that I've gone through all the hard work like you in education and I'm a lawyer.
Right.
And we go through this and somebody gets awarded like 6 to 8 months into it and I do my job right, but Social Security, the compensation, I'm just getting a few months of back benefits. I'm not even at the $5,300 range.
Right, but you get 25% of those few months. Plus, in Title II cases, there's a 5-month waiting period, so they only pay you the first 5 months. So, yeah, I mean, theoretically, you could be an attorney and do your job really well, get the person approved early, and get paid nothing. And I think that's really the ethical issue that, as attorneys, we have an ethical obligation to our client that really exceeds, our desire to get paid on things. The way I deal with it is this. I think that first of all, if you take on a case, you have an ethical obligation to try to win it and win it as early as you can. So you're not going to get paid on it, then don't take the case at that stage. I think most attorneys, again, this is one of the things that kind of led to this book, was most attorneys I know that do a lot of this work don't get involved in cases till the hearing stage because there's so little money involved in it early, and Social Security has a habit of sometimes, if you do win it early, they'll cut your fee. They won't even pay the 25%. They'll pay you $400 or $500 and say that's all they're going to pay you, because they don't see how you possibly could have done any more, even if you've done a lot of work on it. So many attorneys don't want to mess with the case until it's at the hearing stage because the chance to get paid is so dicey and it's so limited. And yeah, that's the problem. And part of what I tried to fill the gap with here was to give some people some guidance as to how to do it at the initial and the recon stages, with the understanding they're probably going to have a difficult time getting an attorney. And if they have an attorney, how hard is he going to really work knowing there's not very much money involved in it?
Yeah, okay. Let's talk about those that have been denied. They have 60 days to request a hearing. When they get that denial confirmation, should they request the hearing on their own, or should they, at that point in time, seek a lawyer? What's the exact moment you suggest?
I personally think that they should probably get an attorney at the time they get denied. I mean, they can certainly fill out the hearing request form, and especially if they think that there is a really strong chance they're going to get approved. And, of course, if they're running late, they can do it themselves. But I think it's probably a good idea to get an attorney involved to do that. Most attorneys, when you get involved in a case, you'll go ahead and fill out the forms, the hearing request form for the claimant. Again, there have been many cases, though, where I've gotten involved and the person filed their own hearing request form because they didn't know about getting an attorney early enough, or for whatever reason they waited. But, yeah, I mean, I think that the best time to do it would be as soon as you get the denial notice for reconsideration.
Okay, this kind of leads us into some of the other work that you do, and you've done a lot of work beyond the Atlanta area in this, and it's actually remarkable. But we've worked at a program with you where you have established a network of lawyers that you've approved, given your stamp of approval, and they're set up throughout the U.S. that people can, below this interview and on the site here, they can click on it and go in and fill out information, and they can actually find a lawyer. So if I have somebody in Des Moines, Iowa, or I'm up here in Vermont, and I need a lawyer that can help me after I've been denied, you've gone out and built this network that you've allowed us to have access to. Somebody can fill out a form, doesn't cost anything, right, to request a lawyer? Okay. And they don't have to use them, of course. But what I'm curious about is what criteria do you look for in the people that are in this network? I mean, how do you see who's good? Are they all good? Of course, that's a loaded question, but tell us about that.
Well, basically what I did was, in the writing I've been doing with this, I talked to a lot of people, and of course there's national organizations that most attorneys who do this belong to, and you kind of get a sense of who's publishing things and who's reporting cases and things like that. And I just got on the phone, quite honestly, and started talking to people. I'll tell you how it developed is when I wrote the book initially, I didn't have any kind of lawyer network, and I started getting emails and calls from people all over the country asking me, can you refer me to a lawyer? And so I was just literally getting on the phone and calling people and talking to them and saying, look, I've got somebody who just called me, and they're in California, or they're in Florida, or Texas, or Nevada, and, I'm looking for, they need some help here. And I wasn't asking for anything. I just said, I'm trying to find somebody who's good. And over the course of a number of months, I just sort of developed these contacts with people, and I finally decided, well, this is something that I need to make a little more formal. And so some of the people that I had referred cases to, I called them back, and we talked. And, when you talk to an attorney, you kind of get a sense, and I sort of know what I'm looking for. I mean, these are people that will take the time if they're willing to talk to me and talk to the folks I was referring to them. They have to show an interest in their client. They have to have, obviously been experienced, have done this for a while. And that's what I'm looking for, is people just that have got some experience, that are nice people. This is a difficult time in somebody's life. You're disabled, you can't function, and you got to have an attorney who will return phone calls, who will work with you. And when you talk to attorneys who do this, you sort of just naturally start talking shop, and you just get a sense of who does it the right way and who sort of has a good approach. And, some of them, quite honestly, I kicked off the program. I didn't feel that they were doing what I want them to do, but I talk to these folks all the time. Mm-hmm. And, I have a pretty good sense just from talking to them that they've got the experience and they've got the background and the skill set to do a good job with the cases. And but those are the ones that I leave on the list.
Great. So just to reflect back to the guide works everywhere, right? The Social Security disability playing field is United States. And then this network covers anybody that would need a lawyer throughout the U.S. Okay.
That's correct. I've got lawyers literally people all over the country.
Okay.
Yeah, some of them cover more than one state, but most of them are in the state that they practice in that state, and they cover that state. And again, these are good folks, and I know them all, and I feel real comfortable with them.
Okay. Let's talk about some other categories. We have people that have expressed, widows seeking pensions. That's one category that people would have questions about, and veterans seeking benefits. Does the guide provide any assistance to those categories?
It does not deal with veterans' disability. Veterans' disability is a completely different system.
Okay.
And I've done a little bit of that type of work, and it's not really actually designed for attorneys. There's no way for attorneys to get paid in veterans cases, therefore there's no not too much of veterans bar that deals with that. Similar in the sense that it's asking disability questions, but the forms are totally different, and that would be a different book.
Okay.
And I've actually toyed with that idea, but I haven't written it yet. The widow's issue is one where Social Security disability does allow a widow or widower to claim on the deceased spouse's earnings records if that widow or widower is 50 years old and became disabled within 7 years of the spouse dying. So you may have a housewife, which is a typical situation, who is 52 years old.
Mm-hmm.
Husband died 3 or 4 years ago, and the housewife is disabled. Social Security disability, the same forms would apply, and that disabled widow's claim would be based on the deceased spouse's earnings record.
Over 50.
So this would apply to that. This would apply to that.
Okay. So that covers veterans and widows. Now, children. You do quite a bit of work for children. Tell us about that.
Children's cases it's a different animal, and I've got a whole separate guide for child cases. And basically, child cases are all SSI because obviously the children have not worked. And child SSI has a different set of standards. Basically, it's a different set of listings. In order to win a child SSI case, you have to essentially meet the listing. It used to be there was a different standard, but now it's pretty much you have to meet the listing. And so my child SSI book really focuses on answering the questions in terms of those listings. Because, again, this is not functional capacity anymore. This is about do you meet the listing. A lot of the child cases that we see are ADHD or ADD, attention deficit problems. Mm-hmm. And, of course, there may be other child medical problems. But essentially, you've got to get forms from doctors to say the child meets the listing. And, again, the child guide, it's actually a little bit longer than the adult guide because I really wanted to go into a number of different child conditions, and the forms can be a little more extensive, but the child guide actually covers, I think I have every form covers ADHD because that's such a big one, and I've got other medical problems as well. So I think I did 3 conditions, physical, mental, and ADHD for each one. So every form is filled out 3 times. So you've got a pretty good guide to fill out the forms correctly for the child cases.
So when you say SSI, I'm just thinking back to the previous conversation, SSI being less than SSDI, and the reason why it's SSI is because they haven't worked. Is that right?
Right. SSI is essentially a welfare program.
Okay.
And essentially what it means is if you're a very low income and you have very little in terms of assets, you would qualify for SSI. People who are making $50,000, $60,000 a year are not going to qualify for SSI. The only thing that a child could qualify from that kind of household is something called the Katie Beckett waiver. This program allows a disabled child to be qualified for Medicaid medical benefits. That is state by state. And that is really beyond the scope of the book because the book's really focusing on the disability. But it's within the scope of the book in terms of proving disability. But in terms of payment, a child from a middle-class household or a wealthy household is not going to get any monetary benefits, but they might be eligible for Medicaid, which in many cases is really what the parents are most interested in anyway.
Are children awarded the same amount? Is it a flat fee for every child? If they meet a listing?
It's a flat number, right. It'll be a flat, it's going to be that $500, $600 number.
Okay.
But it's going to be subject to offset. In other words, if the parents have a certain amount of income, that might be offset by $100, $200, something like that, so that the actual dollar figure the child gets may be $150, $200 a month. When all is said and done, but they do get Medicaid, which provides for medical treatment, which is really, again, a lot of cases what the parents are most after anyway. But the amounts are going to be capped, so it's not going to be very much money. But it can be some. And again, $500 a month is more than nothing a month. And certainly, if you're in a difficult financial situation, it can be helpful.
Mm-hmm.
That is adjusted every year for inflation. So
okay.
It's go up every year.
So this is a separate guide that you have, right?
Correct.
We'll make that available on the bottom of the site as well. Somebody can go and learn about that. we talked about the disability guide, which is your claim to fame that you have there, and then the legal network that you have, and then the children's process. Now, I know we're time sensitive here, and we're just about out of time, but I want to speak about a few other things and some of the work that you've done in this area. But before I do, if somebody was to go in and pick up this book, is there any type of guarantee that you offer with the child guide and the regular adult guide? Like, if they don't like it, can they send it back to you?
Absolutely. Absolutely, can send it right back. I mean, I basically offer money-back guarantee. I mean, I think I put a lot of time into it. I think it's pretty good. And if it's not what somebody needs, then send it back, unused condition, and I'll give them money back.
No harm, no foul.
Absolutely.
Okay. Now, you've done a bunch of other work in this Social Security disability space. You've done state-by-state information where people can come in and learn about that. You run a blog that you personally lend your time. It's like an online legal counsel.
Right.
I find it interesting. You're a lawyer that says, here, you don't need me. You can get my guide. You can come to my site. You can ask me questions, and I'm going to answer them free. And in addition to that, you're even running a radio station. So I want to learn about some of these few things in closing, if you could hit some of the highlights.
Sure. Yeah, I mean, basically, I've got a couple of blogs where I answer questions. I've got the internet radio program. In some ways, it's sort of a selfish reason. The blogs actually help me be able to become a better lawyer, because when you're answering questions all the time, it really does go a long way to help, solidify my information about things. People ask me questions that, quite honestly, I would have never thought of. I mean, I get some really, really insightful questions on the blogs. And a blog, for those who don't know, is a weblog, or it's sort of an interactive website. And it allows me to really stay current with what's going on. I also subscribe to, and I encourage people to do this, other blogs in the Social Security disability area. Some of them are somewhat technical and are written for lawyers. But again, it allows me to kind of keep my eye on what's going on in the area, because the law does change, the process does change, and it allows me to sort of stay current with it. And when I answer questions, a lot of times I have to look things up. I mean, I don't necessarily know off the top of my head. I'll look it up, and now I know, and it really helps me increase my knowledge. The radio station, or internet radio station, is just a way for me to answer questions, because some people don't like to read, and I realize that reading long blog entries can be, for some people it's difficult, especially if they can't see real well, if they don't have a good education. And so the radio station is a way to answer questions and to disseminate information in a verbal way, where I can basically answer the questions for them. Basically, the same type of questions I get, I solicit questions on all my websites. People can ask me the question. If it's something I think has got kind of a common appeal, I'll just add it to the radio program. I generate the radio programs usually 2 or 3 times a month, and it's only maybe 10, 15 minutes at a pop. But it's a chance for me to interview folks. Just like interviewing me, I might interview another attorney who's done something kind of interesting, and I'll talk about case studies and how I won a case, or how a case got lost, or even interview clients and ask them what they thought. It's just a way to sort of add a little bit of dimension to the practice, so I can help people understand what this process is all about. It's really a rewarding area of practice. I've done a lot of different kind of law in my career, and it's kind of neat when you can make a major difference in somebody's life. You go into a hearing, you win the hearing, and now they have some money to live with dignity, and they've got access to medical treatment, and they've got a lump sum coming in. They feel like that they have some of their life back. And nothing better for me to see somebody get on disabilities, and they kind of get themselves together, and they're able to go back to work, and that's really very fulfilling.
Yep.
So this is sort of my way to give back a little bit.
Well, I can see that. I mean, there's a twofold thing, and I want to come back to this blog in a minute, but I see that from the financial incentive being minimal for a lawyer to get involved in the beginning, and people need help to get this process going. So this whole guide thing is a clever idea. Now, I just want to make sure I spend a fair amount of time online and I know a little bit about blogs, but maybe everybody else out there does, and it's just me that does know a whole lot. But from a blog perspective, I just want to understand how it works. If I come into your site and I want to ask you a question or learn something, are you saying that I can ask that question, submit it to you, and then you turn around and post it back, and then those responses that you have, that's what you're referring to as a blog?
Correct. Basically, a blog is a specialized kind of website that, instead of just being something you write and just sits out there, it is designed to be updated on a daily or weekly basis.
Okay.
And so on the blogs themselves, or actually on any of the websites, there's a place where somebody can ask a question. That question comes to me as an email, and if it looks like it's a good question, something that I think other people will be interested in, I'll basically cut and paste it, put it on the blog, and essentially my response to that individual's question becomes part of the, it's in the public now. It's part of the website.
Okay.
So these are questions that I get from folks all over the country. It may be a simple question about where can I find out how much money I'm going to get, which is, again, the form, request for benefit statements. Or it could be a more complicated question, like somebody might write in and say that their medical records were lost, or that they had a drinking problem a few years ago. How do they deal with it? So I'll talk about strategy. It's really just a way for me to answer questions that otherwise I might answer on a one-to-one basis, but I can do so. Everybody benefits from it. Of course, I take all the personal information from it, but it's a way just for me to sort of share the knowledge. Instead of sharing it with one person, I can share it with a lot of people.
Okay, very good. Last thing before we run out of time here is you have state-by-state information that you're going to allow us to tap into. And as I was looking at it, if I understand it correctly, somebody can go in and they can indicate the state that they're in, the condition that they have, right? And
right.
There's a sorting process that you have that will bring up resources that will be beneficial for them for Social Security disability. Is that correct?
Exactly. What I did was I took every state has a little bit different process in terms of the addresses and numbers for the state agencies and just the contact information for the appropriate people. And as appropriate, if there are some strategies that are more applicable in one state versus another, I'll put that in there as well. But I basically have where somebody can go to the site, they can click on their state. It's a drop-down menu. If they live in Arkansas, they click on Arkansas, and it comes up kind of a strategy for winning a case in Arkansas.
Okay.
Or a strategy for winning in Florida, whatever it may be.
Okay.
And then they can also do a select for their condition. So, for example, a lot of the common conditions that I get lots of questions on, fibromyalgia is a real big one, cardiac problems, depression. I took the 5 or 6 biggest ones, and basically I did a whole little section of the website about those conditions. So they can read about strategies of how to win a fibromyalgia case, how to win a heart disease case, an asthma case, a diabetes case. And I keep adding to that. So every time I come up with a strategy that I think has some general applicability on a medical problem, I'll add it to the website. But that's just a way for people to get some more customized information that will relate to their particular situation as opposed to Social Security as a whole, because a strategy for fibromyalgia is going to be different than a strategy for cardiac problems.
Okay. Awesome. Let's recap, okay? I want to see if I get it all right, see if I pass the test.
All right.
Here's what I see and what I think I have this mapped out here. Is some of the key points that people want to take away from this is have consistent, regular medical treatments, right? One of the first things.
Correct.
Second to that is they want to make sure that those are well documented. Keep awesome records. Run this, look at it like a business, and keep requesting your records on like a 3 or 4 month basis. You want to guard those records so you have them at all times. Don't trust the fact that somebody else has them and they're going to keep them and they aren't going to get lost, right? Whether it's your doctor or Social Security. Okay, use the guide to speak to the adjudicator. If you're just starting this process and you want to speak to the adjudicator in their language, using, ideally if you can, one of the 14 listings. If a listing doesn't apply, then you want to work in the right language that will allow you to win on a functional capacity. All right, we in line so far?
So far, so good.
Okay.
Well, I would say when you say the listings, either 14 are listing categories. Within each category, there's going to be 10, 12 listings themselves. So
okay.
It's not 14 listings, it's 14 categories of listings.
Okay.
But otherwise, that's correct.
Okay, and somewhere in there you want to get this Form 7008 that's in the guide and send that in and find out how much money you're going to get paid.
That's correct.
Okay, the next major step that I see is you've gone through, you've applied, you've put your application through the adjudicator. If it didn't get picked up there, they're going to send you back a reconsideration in some areas, not all, right?
Send you back a denial notice, and then you have to file for reconsideration.
File for reconsideration, thank you.
Correct.
It's not common that you're going to be approved at that stage, so chances are you're going to be denied, right?
Correct.
You have 60 days to request a hearing. At that point in time is when you need to come to the bottom of this recording here, back to this the Disability Guide website, and click on the form and go in and find a lawyer. You can use any lawyer you want. And that's what I see as the major steps.
Correct.
Okay, great. I've learned a lot today. Listen, I want to thank you. This has been great. You do great work. You do a lot of complimentary work that's just super for people, and the results that people are getting with the guide are the testimonials that I've read, and people I've talked to have been fantastic. So thank you for your work. Anything in closing that you'd want to share with us? Final tip or trick or bad joke or anything?
No, I mean, I could tell you some lawyer jokes, but I don't know if I want to go there. I would just say that with Social Security, the big thing to remember is that this is a government system. You've got to speak their language. It is a long, drawn-out process. You've got to be prepared, and you have to just, like I think the way you put it earlier was you have to look at this as a business. Your job, if you're disabled for the next couple of years, is to prepare yourself to win disability. It's a very difficult thing for people to sort of consider themselves as disabled. You've got to realize that, if you are disabled, it's tough out there, and you've got to look for every source of income or medical treatment you can possibly get. If you're eligible for this type of stuff, then go for it. Far too many people, I think, just wait around. They don't do anything until it's too late. They've lost their eligibility, they've lost their insurability, and they don't have anything. And then you're really, really in trouble. So I would just say what you said before is make this your business, make this your task for the next couple of years. That's very, very sage, important advice.
Okay, great. Listen, in closing, thank you very much for taking the time. Powerful information. You do great work. Thanks for sharing everything.
Well, my pleasure. Nice to talk to you, Brian.